Today, we will discuss Texas Senate Bill 140, which places new restrictions on the utilization of text messaging for business owners. My name is Chad Cummings, and I am an attorney and a certified public accountant serving clients in matters of business, tax, and commercial law throughout the states of Florida and Texas. I am Chief Executive Officer of the firm Cummings and Cummings Law. I also teach business law at Florida Gulf Coast University and hold 4 degrees, including 2 law degrees, together with a variety of tax, financial, and accounting credentials, which I apply for the benefit of my clients in my practice of law. Our firm website is www.cummings.law. On September 1st, 2025, significant changes to the Texas Business and Commerce Code will take effect, broadening the scope of the state's so-called telephone solicitation laws. For the first time, the statute will explicitly cover text messages, graphic transmissions, and images, not just traditional voice telephone calls. For small business owners, this legal expansion has created significant uncertainty. What kinds of messages are still safe to send? Will appointment reminders or employee notifications now expose a business to lawsuits? What about marketing texts to loyal customers who have opted in? These answers matter because the risks are substantial. Each violation can bring civil penalties of up to $5,000 per instance, private lawsuits under the Texas Deceptive Trade Practices Act, and even criminal liability in certain cases. Texas courts have historically enforced consumer protection statutes very aggressively, which means every business and business owner should treat compliance with this new law as a high priority issue. In a few moments, we will cover a brief guide to what this law means in practice and the specific do's and don'ts small business owners should follow to avoid these costly mistakes. First, do understand what counts as telephone solicitation. The heart of the statute is its definition of the key phrase telephone solicitation. As amended, it means any call or text initiated by a seller or salesperson to induce a person to purchase, rent, claim, or receive an item. The key word here is induce. If the purpose of the message is to persuade someone to buy, rent, or claim something, it is a solicitation. If the purpose is to provide information, such as reminding an existing client of an appointment or notifying an employee of open enrollment in health benefits, it is not a solicitation. Just some quick examples. Your annual tax appointment is scheduled for March 15th at 2 p.m. That would be considered informational and not a solicitation, and therefore not covered by this amended law. On the other hand, another example, schedule today and receive 15% off your tax preparation services. Now that would be a solicitation and therefore would come within the ambit of this amended law. Understanding this distinction is the foundation of compliance. Don't assume that consent or opt-ins automatically protect you, because they do not. Many business owners mistakenly believe that if a customer voluntarily provides their number and agrees to receive text messages, then all types of messages to this number are allowed. That assumption is very dangerous. Consent does not change whether a message is considered solicitation under this new Texas law. A promotional message is considered a solicitation and is therefore subject to the law, even if the customer opted in previously. Consent may potentially reduce exposure under federal law, such as the Telephone Consumer Protection Act or TCPA, but in Texas, the analysis hinges on the purpose and content of the message. Bottom line, do not treat consent or opt-ins as a license to promote anything by text. Consent only ensures that the recipient is not surprised, but it does not insulate the business owner from liability. Do keep informational and promotional messages strictly separate. One of the most common mistakes businesses make is blending different types of content into a single message, which can be very confusing for the recipient. For example, a dentist might send reminder, your cleaning is tomorrow at 10 a.m. Oh, and by the way, we are offering half off whitening kits this week. The first part of that hypothetical message would be considered informational and not a solicitation. But the second part is a solicitation because the law is quote unquote liberally construed to protect consumers. That entire message could be treated as a solicitation. The safest practice here is to create bright lines. Use one dedicated system or phone number for reminders, scheduling, and compliance-related texts. Use another system with a separate number for marketing campaigns and never mix them. This way, if you ever have to prove that your reminder program was not a solicitation, you will have clean records to support your position. Don't underestimate the penalties and litigation risks. The amended law explicitly ties violations of Chapter 302 to the Texas Deceptive Trade Practices Act. This is very important. That means every improper solicitation could potentially be deemed a false, misleading, or deceptive act, opening the door to private lawsuits. Penalties include, among other things, up to $5,000 per violation in civil fines, treble, which is a legalese term for triple damages in private lawsuits if the conduct is found to be knowing or intentional, and even separate criminal liability for violations of registration and disclosure requirements. For a small business, a single texting campaign that goes wrong could result in multiple lawsuits, spiraling defense costs, reputational damage, and probably bankruptcy. Even if you win, the distraction and expense can cripple your operations and reputation. Do be aware of exemptions, but do not rely on them as your primary defense. The statute includes numerous exemptions in Subchapter B, such as securities dealers and publicly traded corporations, licensed insurers and supervised financial institutions, educational institutions and 501c3 nonprofits, businesses soliciting existing customers in very specific contexts, and food sellers and catalog companies meeting strict criteria. While these exemptions are real, they are narrowly construed, and the burden of proving them is upon the business claiming them. For most small businesses, it is far better to stay outside the definition of solicitation altogether rather than rely on one of these narrow exemptions as a possible defense. The key takeaway here is simple. Build compliance around the content of your messages, not on the hope that an exemption may apply. Don't engage in so-called soft selling disguised as information. That will not work. Small businesses sometimes attempt to frame marketing in quote unquote helpful reminders. For example, your air conditioner inspection is scheduled for Tuesday. Ask us about our premium annual maintenance plan. Similar to the previous example we covered, while the first sentence is in fact informational, the second is a solicitation. This type of soft selling can still expose business owners to liability. Courts will look closely at the overall intent and effect of the communication, not just the labels you put on it internally. If the text even indirectly nudges the recipient towards making a purchase, it risks classification as solicitation. Therefore, avoid the temptation to sneak in promotional language. Do maintain strong compliance documentation. The businesses that will fare best under this new law are those that can prove they took compliance seriously. Business owners should, among other things, draft written policies specifying that certain lists, like employee benefit reminders, are never to be used for promotional purposes or selling purposes. Train staff and vendors on the difference between informational and promotional content. Archive every text message sent with clear labels indicating the purpose, and review all templates periodically to confirm that they remain informational and compliant. If you are ever challenged by a regulator or a plaintiff, Contemporaneous records of your ongoing compliance program can make all the difference between quick dismissal and costly and time-consuming litigation. Don't delay preparing until the effective date. The law becomes effective on September 1st, 2025. Now that's right around the corner. Now is the time to audit your current practices and implement necessary safeguards. Review every system you use to contact customers or employees. Identify whether messages are purely informational or may cross the line into solicitation, and segregate lists and phone numbers accordingly. The earlier you take these steps, the easier it will be to demonstrate compliance and avoid last-minute mistakes. Regulators will expect you to be ready on day one. There is no grace period. Do think about broader reputation and trust. Beyond mere legal compliance, which is only a baseline, how you communicate with customers reflects on your brand. People are already skeptical of marketing texts. Overstepping by sending disguised solicitations risks not just lawsuits, but also trust and goodwill. By keeping your reminders clean, informational, and professional, you further reinforce your reputation as a trustworthy resource. In a crowded market, that reputation can be worth far more than any short-term sales boost a risky promotional text might generate. In conclusion, the expansion of telephone solicitation laws in Texas marks a turning point. What used to be a narrow telemarketing statute now extends into the realm of text messaging, where most businesses interact daily with customers and other stakeholders. For small business owners, the message is crystal clear. Keep informational and promotional messages strictly separate. Avoid soft selling in compliance-related texts. Do not rely on consent or exemptions as your primary defense. And document your compliance program and audit your practices now before the law takes effect. By following these simple do's and don'ts, you can continue to leverage texting as a powerful tool for communication without exposing your business to the heavy penalties and litigation risks created by the new law. Compliance is not just about staying out of court. It is about protecting your reputation, respecting your stakeholders, and building a business that thrives under the watchful eye of regulators and the marketplace alike. Again, my name is Chad Cummings, and I hope that you found this information helpful. As always, the information in this video is general in nature and is not legal advice, because legal advice, by definition, must be specific to a particular set of facts and circumstances. Should you have any questions regarding this information or the content of any of my earlier videos, please visit our firm website at www.cummings.law, not .com, but .law, to schedule time for a consultation. I look forward to the opportunity to speak with and perhaps even work with you very soon.